So this is your motion, Adam. Give you the floor. Tell me what you want to. And then we'll hear from Megan.
Absolutely. So I was asked by Megan to pay half of the car. And I looked over our judgment of divorce, and what the judgment of divorce says is that the plaintiff, which is Megan, is responsible for all loan payments for the vehicle, and that she shall not hold the other party responsible for any debt associated with the vehicle.
Yeah,
Um,
I see
so
that.
absolutely. So my ask on this is to ask for that judgment to be enforced, and if possible, if my name to be removed from the loan for the vehicle.
Well, let me ask this question. How much is owed on this car?
Um,
According to the most recent, sorry, Your Honor,
Go ahead.
would you like me to speak?
Yeah, that's fine.
The most recent statement issued July 9th, which was attached with my reply to motion, currently states the total balance owed on the vehicle. Good Lord. Sorry, I'm having issues with my computer screen.
I think a lot of people are today. It's kind of one of those days.
So the current amount as of the July 9th statement owed is $21,871.
Wow. It's a pricey car for a 2020.
It is a very pricey car. It was purchased in July 2021. Due to both of our credit scores at the time, we ended up having an 8% interest rate. And so my reply to the motion included that as of current, I have been paying the entirety of the car loan, and therefore I feel I am meeting that responsibility. However, the discussion around removing his name from the loan, as addressed in my motion, I reached out to my financial institutions. They had me go get an evaluation of the car. I did. And just due to the sheer amount of negative equity in the vehicle, they are refusing to refinance the car. And I asked around to a couple other local credit unions, asked for their input, and they kind of said the same thing. Just with the value of the car versus how much is owed on it, nobody's comfortable refinancing the vehicle. I went and spoke to a couple dealers in the Orem, Utah area where I currently live, and they had all advised that that amount of negative equity would also be impossible to roll over into a trade. The only other option Toyota Financial gave me was to sell the vehicle, and to sell the vehicle both would leave still over $10,000 loan owed to Toyota, which would still, as of the most recent statement, be a joint debt.
Well, that would be if you sell it to Toyota, right?
That would be if you sell it to Toyota, who is the financer on the vehicle.
Right. Yeah. So
But even if,
you don't have to sell it to Toyota if you didn't want to. You could
however,
sell it to Tom Smith down the street, and if he gives you what's owed on it, you can just pay Toyota off, and they're happy. But then you don't have a car, right?
which I also addressed in my letter, stating that selling the vehicle would create a hardship for me, as I earlier this year broke my right foot. And I have been diagnosed with a condition called Charcot foot, which is a condition that causes permanent deformity to my feet. And therefore, being without a vehicle would create just a hardship for me in terms of getting to work and getting to my medical appointments.
Well, let me ask you this.
Yes, sir.
First of all, when did you send this response to this motion to the court?
The motion is dated 7/17 of 2025, and it was mailed from the Orem, Utah post office on 7/21.
Yeah, because I didn't get it.
And I did confirm with Adam on Wednesday that he had received it in the mail, so I was kind of worried that it might not have gotten to you.
Well, there's a lot of layers of, there's a lot of people touching the mail that gets, it could be on someone's desk, who knows. So what, was there a time when you were not making the payments, or have you always made the payments?
So we took out the loan in January of 2021, and at the time, up until the point of our divorce, we had asked for a few deferments from Toyota, just due to either him or me being unemployed. Other than that, up until October of last year, the payments were made from joint bank accounts. After that, when I moved out to Utah, I took on making the full payments of the vehicle,
But you
and I have been
understand,
making them since then.
though, that whenever there's a joint asset and a joint debt, which this is, that even though you two are not together anymore, that your financial practices impact Adam to the point where if you don't make the payment, if you try and negotiate or something along those lines, they hold his credit hostage for that.
Yes, sir. And since our divorce, we have been 2 months behind on payments. We were at the time of our divorce. I have been attempting with everything I can to get fully caught up. However, I have been making a monthly payment every month. And the only thing preventing me from getting caught up on the late payments that we have is the fact that I had broken my foot and have been working less than a full-time load, which has been discussed with my employer, and they've been very accommodating. I've tried to make up hours where I can.
Yeah, I mean, it's going to be a situation like this. I need all payments brought current in the next 90 days and no payments missed, or else the vehicle gets sold. That's the bottom line. I mean,
Yes, sir. I can be caught up within 90 days.
okay. And then all the payments made, because I looked at your judgment, and this is kind of what happens, and it's not either one of your faults. It's the nature of being unrepresented by an attorney. And a lot of people do this, and this is one of the drawbacks, is that the provision that you have, the judgment provides that Megan is in fact responsible for all payments and debts associated with that vehicle. And Adam is asking for his name to be removed from the title. That's not an easy task ever, and the judgment doesn't provide for that. The judgment is the written contract between you and Megan, and a lot of attorneys would have put something in there along those lines, and it would have said, you have to, if the payments are, if there's one payment missed, then the car can either be repoed by the other party or sold or whatever, but none of that's in here. So we have to kind of fly by the seat of our pants with our own remedy here. So what I'm going to order is that all payments on the 2020 Camry be made current, all past payments be made current within the next 90 days. And that if a payment is missed for whatever reason, then the vehicle is going to have to be sold. And you need to, since it's your motion, Adam, you need to prepare an order to that effect.
Okay.
And you have to go down to the Legal Assistance Center on the 5th
Okay.
floor here. They'll show you how to prepare that.
Okay.
and then you should be hopefully okay. Hopefully Megan's foot issues work out because it sounds painful to me.
It does. It does.
And
Thank you.
and obviously, I don't want to cause any more grief for anybody. But I think that's a practical solution. So do you know what I need the order to say, Adam?
I do. From what you told me, I think I have a little bit. But as what you said, that fifth floor, at the courthouse, they should be able to help me a little bit.
Yes, they'll help
Okay.
you a little bit, but I just want to make sure you understand that um, all past due payments be made up within 90 days from today's date, August 1, and that if any future payments are missed, the vehicle will be sold, and either the proceeds split or what's owed on it is split. I mean, it could be what Megan's telling you is there's a lot, which happens a lot in cars. There's some negative equity going on. So who knows? But I think it sounds like Megan is over the hump, so to speak, to getting all these things done. So let's hope.
Your Honor, just for clarity, after those 90 days, once I am fully caught up, is that missed payment, does that go for the length of the loan, or does that go just for that 90-day period?
No, that goes for the length of the loan.
And
I don't want
if
any
it's
missed payments.
and if at any point I need to sell the vehicle just to get a different one, anything like that, will that same split apply?
I doubt it. Well, no, that same split wouldn't apply because it's your car. Okay, so I'm just saying that
I was discussing, I meant for the loan, since the loan is a joint loan.
well, that's obviously a fight for another day. I don't know. I'd have to rethink that because I'm not really necessarily excited of putting somebody in the behind the eight ball with a loan on a dead horse. So that's what it would be, right? Sell your car, you owe them a bunch of money. You can get a good price for it, but let's just get through this and get you guys back on track first, okay?
Yes, sir. Do we need to have a follow-up hearing at all?
I don't think so. You know where to find me, both of you.
Okay.
Thank you,
Okay.
Your Honor.
All right.
I am also looking for representation as well if I need to.